Further hearing of R on application of AA, HTN, RM, AS, SAA, ASM against the Secretary of State's Home Department.
Now, Sir James, we had a point of housekeeping left over from yesterday afternoon.
My Lord, we did, and we're all here to seek to assist the court in any way we can, and we are not going to suggest that you should draw a line through a document that's been handed up. It's for you to decide how much assistance you get from it.
Yes.
We listened with a slightly, perhaps marginally raised left eyebrow to Mr McCulloch's suggestion that it had been knocked up the night before the hearing, but despite that, we're not going to take any formal objection to it being handed to the court.
Our impression is that, by and large, it's giving us in a different form, perhaps a more focused form, the references which we would find going through their submissions.
Our Lord, yes, of course. I mean, it's a matter for them how they present their case. Sometimes it's more helpful to see the actual shape of it a little bit earlier, but yeah, we're not going to take a formal objection.
Very well, thank you.
Also, my reply, if I may. The first point that we make is that it's accepted by Mr Hussain that the detailed and public commitments and assurances that have been given by Rwanda, if complied with, will be sufficient to deal with any real risk. And I went through the nature of those commitments in opening, and I don't propose to do that again. But that acceptance that the content is adequate to protect against any real risk in relation to the refoulement processes in Rwanda that they set up. That acceptance is of obvious importance because it means that the question then becomes not whether adequate assurances have been given, they have. The question is simply whether they will be complied with. And given that that is the position, it perhaps does not matter, given that acceptance of the adequacy of the content of the commitments, how they came into being. However, it is at least to be noted, because it links them to the past and to past concerns, that they were shaped by and did respond to concerns that had become evident prior to their being entered into. Mr Hussain made the submission that that was belied by the facts. We submit that it is not belied by the facts. There was a series of engagements with those with an interest in these arrangements and with the safety of Rwandan asylum processes and past concerns. There were a series of engagements in March 2022. And you were taken to the record of the meeting, or the meetings, with UNHCR at page 2624. I'll just invite you to get that page up again. Just to put it in some form of context. These notes and this record were appended to one of the CPINs, one of the notes that was produced. I think the version was May 2022, starting on page 2573. And this is Annex 8 to that, but you'll see its nature. It records a series of interviews and meetings with various interested parties and bodies in that March period, that late March period. And the one beginning at page 2624 runs effectively through 10 or so pages and records a detailed series of questions and answers involving UNHCR. You will also note that the very next interview at A9, Annex 9, starting on page 2634, is with the National Commission for Human Rights in Rwanda. And it was their reaction to worries about discrimination that I referred you to earlier on page 2636. Do you see the passage in the middle of the page, anti-discrimination policies in law? anti-discrimination laws in constitution, discrimination here is a crime, has roots in our history, and so on. That was from the interview notes with the National Commission for Human Rights of Rwanda. So those sorts of discussions, those sorts of past concerns, did feed into the nature and content and detail of the commitments, and that is so is expressly clear from the evidence that is before this court, including in particular, and I think I gave you the reference in opening, but just so you have it, in case I didn't, paragraph 28 of Mr. Armstrong's statement on page 2662, where he gives the example of the provisions dealing with reasons in the process note verbal. You'll recall those as an example of something which was, as it were, reactive to the sorts of meetings and worries that people have been raising beforehand. The remaining complaint that Mr. Hussain and indeed to some extent UNHCR repeat is that they were not themselves, that's UNHCR, were not themselves consulted on the commitments actually being considered. That's what Mr. Hussain, I think, meant by his repeated references to the meeting happening blind. And my submission in answer to that is that there was no necessity to involve them in that process. Those were interstate discussions and interstate negotiations and arrangements. And in any event now, given the acceptance that the assurances are in their content adequate to protect against a real risk, it's perhaps an irrelevant point in any event. So that's the first point, accepted on all sides that the content is sufficient. So the second point is an accordingly point. So Mr. Hussain accordingly says that the fact that he accepts the adequacy of the content is irrelevant, his word, because he says two main things. He says, A, it's irrelevant because we, that is the government, have discounted the past and the present, as he puts it, and B, that whatever the commitments that might have been given, the system in Rwanda cannot be fixed given the concerns, scale and weight of the concerns that have been raised. As to the first of those, the past and the present being treated as irrelevant, my submission is that my fundamental point on all of this is not to be dismissed by mischaracterization. The concerns that have been raised have been considered. They have not been ignored. On the contrary, as I indicated, they fed into the design and the detail of the commitments sought and given. And no one, I should make absolutely clear, no one on this side of the court contests that a number of serious concerns have been raised and were raised, nor that they were considered, both in the lead-up to the commitments being given, e.g. in the manner that I indicated under point 1, and also during the litigation that almost immediately followed. And the sequence was pretty truncated, as you will recall, with the arrangements being entered into around about April 2022, the litigation then being started very, very quickly, and in effect the evidential shutter coming down in July 2022. So my case is not that the past can be or has been ignored. However, we do make two key points. First, it is neither necessary nor even practically possible to seek to establish the truth or otherwise of all of those concerns. And that is because, leaving aside the practical difficulties of doing that, that is because they can be considered and taken into account, as they have been, both in the design of the commitments and, to the extent necessary, in the operation of the system which is so set up. The second point we make is that the question whether the commitments, adequate in their content, can and will be complied with, does require judgments to be made. The starting point is that they were, in fact, entered into, knowing full well the seriousness of them. Don't repeat all the points I made in opening. It's key to note that the commitments were given not just as a series of detailed procedural guarantees, as it were, but with the clear and express aim or objective enshrined in the MOU in paragraph 2.1, namely to create a bunch of systems that were compliant with the Refugee Convention and other international standards, as the keystone to those commitments. And I did want at that point just to pick up one feature of Ilias. I'm not taking Ilias out of turn and dealing with procedural matters now, but one feature of Ilias which it is at least worth noting. Can you, if you would, take up Ilias again? The bit of Ilias I want is on page 7820. And you will recall the facts of Ilias, I don't go through them again, but can I just pick it up at paragraph 158 on page 7820, please? You will see that it was acknowledged there, particularly in the second half of 158, that there was consistent general information that at the relevant time asylum seekers returned to Serbia ran a real risk of summary removal to the Republic of North Macedonia and then to Greece, so chain refoulement, and therefore of being subjected to conditions incompatible with Article 3 in Greece, with some fairly familiar sounding allegations from the UNHCR about lack of administrative capacity, summary refoulement, denial of access, and so on at 158 and 159. But the significance against that backdrop of this part of Ilias is that you will see what they say at paragraph 161 over on page 7821. It is significant, say the European Court, furthermore, that the risk of summary removal from Serbia to other countries could have been alleviated in this particular case if the Hungarian authorities had organised the applicant's return to Serbia in an orderly manner or through negotiations with the Serbian authorities. However, the applicants were not returned on the strength of an arrangement with the Serbian authorities, but were made to cross the border into Serbia without any effort to obtain guarantees. So we respectfully submit that Ilias is at least illustrative of the proposition that the European Court will attach very significant weight to the position if there are, or equally the flip side, if there are not, negotiations leading to assurances and guarantees. And there is nothing in the European Court case law that we have found which is remotely close to this sort of exercise. Of course, the court has to make its judgment about whether or not there would be a real risk in Rwanda, and I'll come to the capability and capacity issues in a moment. But here you do have, and it's important that you do have, because they contribute to the practical and effective nature of the assurances. You don't just have what you often have, which is an assurance that a particular individual who might be removed will be treated properly. You have here a series of detailed procedural assurances which are specifically designed to ensure that no one is in any doubt about what the requirements need to be of the system that Rwanda is expected to operate, a system which, again, I emphasise, is accepted to be adequate in its content by reference to those commitments. Can I then pick up a series of points in response to Mr. Hussein's submissions about how that all works? And I start with a proposition which might be obvious, but it perhaps deserves repeating in the light of the submissions, which is that inviting the court, as we do, this court, to place weight on and or give respect to the judgment of His Majesty's government in relation to assurances and all things to do with them and whether they will be complied with, does not alter the legal test. I made the point, and I don't return to it, that there has never been a dispute, and there is not now a dispute, that an Article 3 judgment on real risk is ultimately for the court. The judgment points that I make are about the manner in which the court determines whether there is such a risk in the context of assurances. It's about the manner. And I do want to emphasise a couple of points about what our case is not, in the light of some of the submissions that Mr. Hussain made. He repeatedly suggested, alongside various adjectives such as heretical and extravagant, that our case was that, or was tantamount to being that, the courts were to be excluded, his word. That is not our case. The obligation on the courts applying Othman is to examine whether the assurances provide sufficient protection in all the circumstances, underlined 3 times, and having regard to their likely practical operation. That is 187 to 189 of Othman, cited by the Divisional Court, with all of the factors that they referred to. See page 7519. That is what, in that paragraph, i.e. in paragraph 187, that is what the European Court meant by the assurances or assurances not being in themselves sufficient to ensure adequate protection. Because the sentences then follow in 187 make it clear that you have to examine those practical issues. And we entirely accept that that is the position. Nor, I should make absolutely clear, do we dissent in any way at all from what my Lord Lloyd-Jones said in Zabolotny, in particular paragraphs 45 and thereabouts, page 6644, essentially to the same effect. Examine the adequacy of assurances. That is a job for the court, and you do it by examining all of the circumstances of the case. Nor, as follows from that, do we dissent in any way from the proposition that my learned friend took you to from Lord Hoffman in Raymond, final sentence or two of paragraph 54. We do not assert, for obvious reasons that I've just explained, that there is some form, to use Mr. Hussain's word, of exclusionary principle at play here. Nor, finally, on the principled approach, are we in the territory in which any of the references to precautionary or preventative, you'll remember the emphasis my learned friend Mr. Hussain put on those, effectively making the submission that those references advanced his case in some way. We are simply not in that territory. The suggestion appeared to be that the reference in the speech of Lord Hoffman in Raymond to precautionary played in my learned friend's favour. They plainly don't. What Lord Hoffman was dealing with when he referred to precautionary in the context of that statement in his speech in Raymond was an entirely different concept and an entirely different context. His point was, and his use of precautionary, was all to do with avoiding, on a precautionary basis, avoiding damage to national security. In any event, the preventative element, to the extent that that's different in the references to which he took you, is already built into the real risk test. That is its essence. Its essence is preventative. That's why it's a real risk test. You simply apply it. And moreover, do not blur it, as my learned friend sought to do, with points about the need for a suspensive remedy. That raises, as this court will be very well aware from previous iterations of these proceedings, that raises its own discrete issues at the interim stage of proceedings, not at the stage when you are applying the real risk test. When you're applying the real risk test, that's the test you apply. So none of that, we respectfully submit, is our case. What our case is, to take the next little heading, is rather as follows. We say that all of the circumstances, to take that phrase, here include the fact and the detail of the commitments entered into for their specific purpose and with all of the incentives that surround and are in them. They include the fact that, as is common ground, their content will secure safety if they are complied with, and importantly for the purposes of this point, that it is appropriate, as the repeated case law that I took you to in opening or referred you to in opening has made clear, it is appropriate to accord considerable respect to the judgment of His Majesty's government on that issue, whether they will be complied with properly. We do not, as Mr. Hussain appeared to imply, simply rely on case law from the national security context, and nor do we need to. The degree of respect which this court affords to judgments of this kind made by the government depends not upon establishing a direct analogy with context. It depends upon the principled underpinning, frequently considered by this court, of that doctrine, including in particular expertise and constitutional propriety. And you have case law indeed from that national security context, although that is adventitious for the purpose of this point. You have case law from that context, Raymond, Begum, which analyses how that idea works. But the importance of that case law lies not in the context or its specific application to a particular context, but, as I say, in that principled analysis. And I add for good measure that this doctrine, this principle of respect, is not dependent upon the source of the power being exercised, either whether or not it is legislative or whether or not it is a prerogative power or some other form of power. But for good measure, you also have cases of which you will be very well aware in other contexts which are very, very close to home. Take, for example, the Lord Carlisle case, with which you will all be very familiar. That was a case about foreign relations. The case, as you know, concerned the freedom of political speech, where the court is most anxious to limit restrictions, and yet the court gave very considerable weight to the assessment of ministers on the likely conduct of the foreign state in question. In that case, it was how would Iran react if Ms. Rajavi was allowed into the United Kingdom. She was an opposition Iranian leader living at the time in France. And you have the same point, exactly the same principled approach, exactly the same analysis in another foreign relations case that I referred to in opening, Lord Justice Laws in Al Rawi, which is all about whether or not the Foreign Office should get involved in making representations in relation to someone who was being held in Guantanamo Bay. But that context, if necessary, we say it's not, but if necessary, that context was pure foreign relations, and the same principled approach applies. It's important perhaps here to recognise, in considering the judgments in question, that the respect in question would plainly, perhaps paradigmatically, attach to a judgment about good faith. But it also applies, we submit, more broadly to intent and to commitment of the foreign state, not merely to complying with the letter of the commitments that it has given, but also doing so as to achieve the stated objective, delivering a compliant system. So if you're dealing in good faith as the foreign government with areas where there might be some doubt about what the commitment requires, or which requires practical developments to give effect to the commitment that has been given, if any, then the judgment ultimately is about whether or not they will devote that time and resource, that effort, whether they will provide that commitment to make the system work in accordance with that objective. In other words, to deliver systems that will comply with the Refugee Convention and ECHR standards. And of course, that then takes one into my B point, little b point, which is the capability of delivering on the commitments that it has given. And I do submit, for the reasons I've just given, that weight and respect is to be accorded to the government's judgment here too. It's undertaken, that's Rwanda has undertaken the commitments on the basis of the aim as set out. Cooperation and the building of the system, the building of capability, is built into the system. And it is ultimately a question of judgment and of prediction, how a foreign state in this position can be expected to behave. And that is a judgment which we are well placed to make. I do not elide good faith and capability, as I've been accused of. We do, however, say that there is plainly a relationship between them in the way that I've just described in the present context. And for good measure, just in case you thought the entire case on judgment rested on our ability to make proper judgments about, predictive judgments about the actions of a friendly foreign state. There is, if you will forgive me making an obvious point, real and deep expertise, if necessary, within government about the essentials of a safe and adequate set of processes to deliver compliance with our international commitments, brackets, the same international commitments that are the subject of the objective in paragraph 2.1 of the MOU. The whole institutional weight of the Home Office and of broader government and all their experiences behind that. And those essentials are not ultimately, the essentials of a system which is satisfactory are not ultimately of impossible complexity. They are relatively simple at core. So what then about the suggestion that we are not as expert? I don't want to get into a weighing match on this, but we are not as expert as the UNHCR on Rwandan systems. No doubt they do have, of course, long experience, as no one denies, within Rwanda. But we, that is the government, are the experts in assessing the core issue about how the friendly foreign state is likely to behave. And it is important to note that this is not a standard case within UNHCR's expertise as to the ability of the foreign country to operate an adequate system. Rwanda, it is important for you to clearly bear in mind, we submit, is not on its own here. Here, the assessment is of Rwanda's ability to operate an asylum system with very considerable training, monitoring and other assistance of a continuing nature from the United Kingdom. It is not only, in case I gave that impression in opening, it is not only Rwanda which have strong incentives to make the Rwandan system work. The UK itself has a very strong interest. This policy is a very, very high government priority in making that system work. If it doesn't work properly, that fact will be swiftly communicated back to lawyers in the UK who will bring judicial reviews if necessary. If successful, no doubt the removals will stop. So the removal deterrent to the small boats crossing the channel will become extremely problematic if the system doesn't work. The UK government, is the point, has a very, very powerful incentive itself to ensure that Rwanda does operate a fair and effective system. And so even if one assumes that all the concerns that have been raised are well-founded, and you're well aware that some of them have been questioned and disputed and so on, but even if you assume they're all well-founded, the same question still arises. Are they going, even if there have been poor practice or worse in the past, is that going to be repeated? And that's a question of judgment about whether or not the Rwandan government will conform to its commitments. I wanted to say something very briefly about the number, because the number appeared to have something of an impact. The number, I mean, in this context, was bedeviled by 3s and 2s, but the number in this context was 323 of the UNHCR people who you were told were on the ground in Rwanda. The point I wanted to make about that is simply this. 323 UNHCR people are not sitting there poring over the Rwandan asylum system. You have the historic figures, the numbers flowing through that asylum system, in part, I think, because on the evidence there have been very significant numbers coming from the DRC and from Burundi across the border, and if sufficient numbers come over, the Rwandan attitude is there's a crisis, so they get the status, as it were. But the numbers going through that system to date have been very small. 60 or 70, I think, is a number that sticks in mind. There aren't, as it were, to trivialize it a bit, there aren't 5 UNHCR people looking at each individual case that has flowed through the asylum system. What that number of people indicates is that UNHCR is entirely properly and actively engaged on the ground, in particular in managing the various projects that it has in Rwanda. So there are, as I say, lots of refugees who have come over the border at various points and are in camps or have been in camps in Rwanda, notably because Rwanda has extended the arm of protection around them from, in particular, Burundi and DRC, but also because, as you've seen from the evidence, and if you want the references, it's in Botnik 2, paragraphs 13 and following, page 2808, but also because the UNHCR itself operates a system called the ETM, or the Emergency Transit Mechanism, whereby, as it were, they evacuate people from difficult hotspots such as Libya and Niger, and they go to Rwanda, to the facility organised by UNHCR in Rwanda, operated pursuant to an MOU with the Rwandan government. They go to that system for the purpose of UNHCR processing them and relocating them or resettling them if possible. But so the 323 number must not be taken as being a number, as it were, of all of the people who are devoted to assessing whether or not the Rwandan asylum system is appropriate or working well. That's the short point, made rather at some length, I'm afraid. But I wanted to just deal with that number. Come back to the question. One can pose the question in a, perhaps in a rather, the key question, and perhaps in a rather more objective way, in this way: is the system in Rwanda so broken that it cannot be fixed? And we do submit that it's an ambitious submission and overreaching position to take, to suggest that Rwanda simply cannot, with good faith and intent and cooperation and the investment of the United Kingdom, simply cannot comply with those commitments. And we submit that the past evidence of concerns does not come close to establishing that. I wanted, however, to pick up on certain points about capability, using that in the broadest sense, if I may, and to try to respond to some of the points that Mr. Hussein and UNHCR to some extent have made. The first point to make in relation to that is that we, on our side of the court, have not approached this case on the basis that we only have to deal with numerical capacity. That was a submission that Mr. Hussein made. That is yet another straw man, we submit. I made specifically clear in opening that I was dealing with that issue because it's important to acknowledge as a positive point that the building up of the system and the preventing it from being swamped and all rushing decisions and all the pressures that are put on a system if it is overloaded with numbers, that all of that was dealt with specifically and in terms as part of the detailed commitments that have been given. My submissions to you and to the Divisional Court and indeed in the Lord Chief Justice's analysis and the analysis of the Court of Appeal all consider in some detail the key areas of concern, and I don't intend to travel back over all of those: legal assistance, how it's provided, interpreters, the processes, all of that. The conclusion that is reached, however, ultimately, is that as concerns taken properly into account on that basis, they do not prevent compliance with the commitments that have been given. But secondly, I wanted to revert, because Mr. Hussein sought to make some capital of it, to the question that Lord Lloyd-Jones asked me very early in my submissions, which is whether or not there is a parallel system. And I accepted, I hope correctly, as you've seen from the documents, that it isn't a parallel system. But that adjective contains little or no magic. The magic, I submit, lies in the detail and the content, brackets unchallenged as adequate, of the commitments, and the fact that this will be a changed system. Its nature as parallel, we submit, does not advance any side's cause. What matters is the extent to which it indicates that there will be a changed system. And I take that wording, as it were, of a changed system from the passage I think you were taken to. I don't invite you to go back to, but if you wanted, it's in that Government of Rwanda memo, I think, or note verbal from the Government of Rwanda at page 3208. Whether it does or does not apply with all the commitments to others not relocated from the UK under the arrangements, that changed system, is really neither here nor there. The risks under consideration are and are only in relation to the UK cohort. That's the focus, that's the proper focus. It's been said, well, there's been no change. The present is the same as the past. As to that, we respectfully submit that that inference cannot be drawn at this stage. I mentioned the dates earlier on. The arrangements themselves are entered into in April 2022, and then we have, as it were, a cut-off, evidential cut-off, in early July 2022 when the decisions are taken. 5th of July, I think, was the date for those decisions. Nor do I accept that to the extent that there are any remaining issues, they are incapable of being entirely and appropriately and adequately dealt with through the process which is evidently envisaged by these arrangements, in which both state parties are heavily invested, of seeking to make sure that it does deliver those commitments and it does secure the objective referred to in the MOU at paragraph 2.1. Reasons was given as an example of the no change, present is the same as the past point that Mr. Hussain sought to rely upon. But as I pointed out in opening, the provisions of the process note verbal in relation to reasons are crystal clear. See for your note paragraphs 4.8 and 4.9 on the nature of the reasons that have to be given. And Rwanda, for good measure, has positively and expressly accepted that, as it calls it, the template needs to be and will be changed. See page 3216, a reference again I think I gave you in opening. That's the second point about parallel system. The third point relates to the DGIE, on which Mr. Hussain sought to found a large part of his submissions, and which, as you saw, came very much to the fore in the written note that you had from UNHCR. So it's right that I should seek to deal with the points that are made there. It is said, as I understand it, there continues to be a risk despite the commitments, because DGIE, you can infer or conclude from the past concerns, will remove individuals relocated under these arrangements because it did or may have done so in the past. The overarching point to make is that any removals at the airport, which is part of the strands of concern about the DGIE's past conduct, any such removals simply will not happen under our commitments, under our arrangements. And that is not least because, as I took you to in opening, those commitments specifically provide for an approval process, a prior approval process. No one gets on the plane unless Rwanda has approved their transfer, and their transfer is then obviously and clearly under the commitments for the very purpose of determining their asylum claims, with all the incentives attached to that. So that if the DGIE did seek to remove people arbitrarily in that way, without Rwanda considering and determining the claim in the way contemplated by the arrangements and committed to, that would be tantamount to an act of bad faith, which no one alleges. To which my learned friend Mr. Hussain and indeed the UNHCR say, oh, well, don't worry about that, because the answer is that it could well be the underlings. It's the underlings who are doing it. It's not an act of bad faith by the Rwandan government. That, we respectfully submit, is both constitutionally wrong and entirely unrealistic. It's never going to go undetected. There are audit trails, there are IT systems, there is monitoring. The UNHCR will be on the ground. There is simply no way that someone approved under this system, logged and entered into the system, is then going to be removed with impunity without their claim for asylum being determined. So that's the first aspect of DGIE, which we respectfully submit is just completely ill-founded. Secondly, it is said, oh, well, there's a long tradition of DGIE making what's described as off-the-book decision-making, and that they'll play an unofficial gatekeeper role in which the asylum claims are never referred to the RSDC for a decision. Same points. The whole purpose of the MEDP is to transfer individuals to Rwanda for the processing of their asylum scheme, or their asylum claim, and they consent before the transfer in each case. And it ignores, if necessary, it ignores the very real financial incentives for the government of Rwanda to make decisions on these asylum claims. And of course, as I emphasised in opening, and I'll come back to very briefly, there are practical arrangements in place to prevent cases, as it were, slipping through the information cracks. So the third aspect of complaint about the DGIE, again, needs to be split out, third of four perhaps, which is the role of DGIE and the processes that follow. The assurances, as you're aware, provide for a, quote, an objective and impartial process. And there are attendant procedural safeguards that have been considered in immense detail and with immense care, both in the MOU and in the process note verbal. And there is the right of appeal to the High Court at the end of all of this. So if there is a concern about the DGIE role, it is answered by those procedural guarantees. Ultimately, it will be evident if a case has in some way not fed through the system properly. If it has fed through the system properly, then it is entirely clear from the commitments and the processes that they envisage that what will happen is a decision-making process which starts as the decision-making process with the RSDC. And the RSDC themselves, if they're not satisfied about the adequacy of the interview, can themselves interview claimants. The claimants can themselves make representations to that body. So the RSDC is the decision-making body, the start of the decision-making bodies, and then you go to MINEMA, and then you go to the High Court as necessary. And indeed, there was evidence before the courts below that the DGIE, in fact, does not and or will not even make recommendations to the RSDC. See for that purpose page 3214. The Government of Rwanda say in terms, DGIE does not make any recommendations that may influence the outcome of the RSDC decision. And then at 3283, again, Government of Rwanda, the RSDC is the sole entity empowered by law to determine the refugee status of an asylum seeker. And of course, as you know also, as part of legal representation, legal representatives will have access to the file. So the process and who did what when and how they did it will be visible ultimately to legal representations if necessary or appropriate. See page 3183 for that purpose. So the final point in relation to DGIE is the resurrection of what is described as the country X point. That was DGIE taking decisions for foreign relations reasons. Do you remember that? There was an unnamed foreign countries which it was said DGIE had removed people or didn't admit. So the UNHCR claim and position and concern is that in those cases DGIE did not admit the claimants from that particular country into the asylum system, presumably because they were concerned about offending the country or whatever it may be. 2 points to note about that. First of all, as the UNHCR confirmed to the Divisional Court in terms, none of the claimants come from that country. That may matter less given the nature of this systemic challenge. What matters more is that the answers to this concern as a concern are exactly the same as the answers I gave you in relation to possible turning away at the airport. There's prior approval, people come into the system, they're logged as doing so, and so there is no risk at all of turning someone away without access to any form of system when they've come from the United Kingdom under that approval system because of foreign relations concerns or any other concern. That takes me into my fifth topic in relation to compliance, which is monitoring. And we do submit, and I maintain the submission, that monitoring and all its various processes is key. I don't trace through all the forms of monitoring because I did that in opening. There are layers of monitoring, both formal and informal. They include the UNHCR and will include the UNHCR. And indeed, it might be thought rather cheekily that the lots of personnel point that Mr. McCulloch made rather plays against him here. But the aim and purpose of monitoring is obvious. It is to give practical teeth to the commitments whose content is accepted to be adequate. It is to ensure that the commitments are adhered to and are rendered practical and effective, not theoretical. That is why, no doubt, monitoring was specifically identified as one of the key factors by the European Court in Hoffman at paragraph 189. And of course, it is not just, monitoring is not just a cure designed to correct errors if they occur, although, of course, part of it, and indeed part of the terms of reference, as you saw in opening, it is to ensure that if there are problems, they are picked up. If there is improvement to be made, it is made. If there are issues to be identified, they are identified. That's part of it. But it isn't just to cure or correct error or secure improvement. It's also designed to have an impact and effect, because Rwanda will well know that those layers of oversight exist. This is therefore, and for that reason, a from day one and continuous practical safeguard. And that is all the more so because, as I pointed out in opening, those systems are backed at every stage by provisions that are designed to secure access to the necessary information and access to the necessary processes, including a detailed IT system audit trail of each and every case relocated under these arrangements. No doubt, in principle and in theory, some concerns are more difficult to monitor than others. No one would seek to deny that. And that is why, no doubt, my learned friends sought to build on what Mr. Hussain kept calling bias, but to use the clearer name, is in fact a concern about discrimination. I don't go back over all the ground I went through in opening. My submission, as you know, is that what Lord Justice Underhill described as statistical frailty undersells the concern about the basis for an allegation of that kind. There are a tiny number of cases which are said to base that allegation at core, where indeed the underlying facts of those individual cases, let alone the inferences that are drawn from them if the factual basis is accurate, is disputed anyway. But even if all of those cases did indicate that they were instances of some form of biased or discriminatory treatment, that would not provide a proper basis any more than findings of discrimination against an institution or government department in the United Kingdom would do. They do not provide a proper basis for characterising DGIE as an institution, as in effect institutionally racist. That's the allegation. And in any event, even if one could do that, or even if there was a concern about that, the DGIE will not be taking the decisions anyway. It's the RSDC and related subsequent bodies that will be doing that. And of course, if there is that concern, or perhaps more accurately, now that that concern has been raised, everyone involved in the monitoring arrangements can and no doubt will keep a thoroughgoing eye on that issue as cases begin, or if cases begin to flow through the system. So that's the fourth point, monitoring by way of response. Fifth point, High Court appeal. It is provided for in the arrangements, and its function and role within those arrangements is regarded as important for obvious reasons. Its jurisdiction, which I don't go back to, is set out, as you will recall, in paragraph 5 of the process NV, full re-examination of facts and law. Whether that's the same as an appeal or the same as a de novo consideration can be a matter, no doubt, of argument, but that's the jurisdiction that's been conferred upon it under that set of arrangements. It will therefore, in fact, be available to anyone who is relocated under these arrangements, and every one of those people will have access to legal advice and at that stage legal representation to enable them to consider whether or not they wish to choose to exercise that right. My Lord Reid probed the question, well, why have there been no appeals to date? We don't have evidence about that beyond July 2022, so it's a pretty short window from when the MEDP was put into place. But to take one of the posits that I think my Lord had in your mind, does absence of reasons or a concern about the lack of reasons provide some form of indication as to why that may be? Can I just briefly respond to that? The answer to that concern, if it does exist, if that is an explanation to date, I'm not sure it is, or one can draw that inference, but if it were to be, the fact of the matter is that reasons in detail on fact and law, as we saw from the process MV, will have to be provided under the MEDP. But secondly, and in any event, because of the jurisdictional nature of that access to the High Court provision, full re-examination, it may well, in any event, be of lesser importance, because the High Court will be fully seized and fully able to take that full re-examination role under the arrangements that have been set up. So even if you were to characterise it as an appeal, if one of the points was, when you've taken your legal advice as is guaranteed also under these arrangements, if one of the concerns was we don't know quite what basis the decision was taken on, that would be an appeal point. And that would be, as it were, all the more encouragement to the court to exercise the full re-examination jurisdiction conferred upon it. My learned friend, sorry.
When I asked about this, it wasn't simply the absence of appeals since the MEDP. As I understood it, there simply hadn't been appeals to the courts in asylum cases.
Yes, I don't know what the Rwandan system previous to the MEDP looks like.
We're told, aren't we, that the right of appeal
had existed forever.
Was it 2016? I may have got the precise year wrong, but it had been around for some years.
18, I think. It was
maybe 18, but it was around for some years before the MEDP came.
Yes, my Lord, I don't know. We don't have any evidence, as I think my learned friend accepted, we don't have any evidence as to why that is. We know that the number of cases flowing through is relatively small, and it may be that's part of it. It may be that there are all sorts of reasons feeding into that. But my core and fundamental point is it's a right that is guaranteed under our provisions. The jurisdictional reach of the court is set very clearly. The right of access to legal representation, if access to justice is some explanation for the bar of the previous position, that will be guaranteed under these arrangements as well. So whatever the position may have been, we submit that the commitments are very, very important so far as that is concerned. And of course you have my submissions, which I don't repeat, about why the concerns that were identified by the Divisional Court do not read across into our situation, into our position, and indeed the limited and circumscribed nature of the findings that were actually made by the Divisional Court there. My learned friend Mr. Hussain said, and I simply invite you to note it, I'm going to give you one reference, simply said that this point about judicial independence had been simply ignored. There was, as he put it, complete silence on our side about it at the time of the arrangements were entered into in April 2022. But, and perhaps it is to be noted in relation to that suggestion, the UNHCR, for whatever reason, my learned friend Mr. McCulloch sought to suggest that this may have been for diplomatic reasons. I think an earlier footnote to one of their earlier sets of observations acknowledged they had no expertise in relation to judicial independence, but for whatever reason, they have not and did not raise concerns about that, and nor did anyone else at the time we were considering the nature of the arrangements. The point was raised, in effect, for the first time in the litigation on the back of the Divisional Court case, and in any event, the issue of the functioning of the Rwandan judiciary was the subject of consideration in the CPIN, which relied on, I think, a World Justice Forum set of statistics. And of course, I fully acknowledge that there are statistics and damned lies, but there is a set of analyses in the CPIN based on that World Justice Forum analysis, which effectively places judicial functioning and judicial holding of government to account in Rwanda pretty close to, if not at the top of the regional league table, for what that is worth. So there was no overt suggestion of a problem on that front, indeed quite the reverse in relation to that. The reference for that is page 2478. That's High Court appeal. Sixthly, Israel, the Israel-Rwanda position. I do not, I submit, and did not have to seek to chase down the detail of non-compliance, if that's what it was in the past. The need was to design a system for the UK court to be relocated for the purposes that you see set out in the arrangements, and to seek to ensure that they would be compliant with those international obligations in the future. And they bound Rwanda in the way that is indicated through the clear public commitments that have been given and the incentives built in. There is nothing to indicate that there was anything like the same level of detail. We know full well that the Israeli arrangements were not made public, unlike ours, which is an important protection, as Othman acknowledges, but there's nothing to indicate there was anything like the same level of detail or specificity as to process, prior approvals of cases flowing through the system, monitoring and all of that. The concern, ultimately, that is raised by UNHCR, quite understandably, is that there may have been a series of removals or refoulement to a third country in significant numbers, despite guarantees that may or may not have existed in relation to those Israeli arrangements, and without any determination of their cases. To which my answer is that there is no real risk of anything similar happening here. The commitments are crystal clear about what processes are, and are crystal clear that determination and treatment in accordance with the Refugee Convention is required. And this is, we submit, a bit like a point I dealt with earlier, a point which is in nature prepared to wound but afraid to strike. It would be a clear act of bad faith for the Rwandan government in any of its forms to seek to remove large numbers of people to another country without determining their claims. That will be picked up. There is no escaping from that. It's no answer to say, well, and I think the same point was being made, well, it may be other people within government, maybe one bit of government not acting in a way that is not sanctioned by another part of government. See Chahal, I think, said Mr. Hussein. Well, Chahal, of course, was extremely different, if I can put it politely. In Chahal, as I recall it, the concern was that I think it was the Punjabi police were operating in effect independently of any control. It's a very, very different set of affairs, and no proper analogy can be drawn with Chahal. Our submission, therefore, is pure and clear protection against any risk of the same thing happening under all of the detail of our arrangements and our commitments, and it would be an act of bad faith to conduct themselves in that way in relation to any UK set of relocated individuals for the reasons that I've given. So the conclusion in relation to this set of submissions, and indeed the overriding point, remains there is a massive detail in this case with a series of concerns about the past, about the operation of the Rwandan system in the past. Those have been acknowledged as such. They can't be determined, but that does not mean they were ignored or have been ignored. The core point, however, remains that the commitments have now been given. They are detailed. They secure rights which are in a way which is practical and effective. Their content is accepted to be adequate to protect. There is no challenge to good faith. There is no challenge to the intent. There is no challenge to the objective. The question is whether Rwanda is simply incapable of operating them. And the past, we submit, for all its concern, does not come close to establishing that. And indeed, for good measure, our judgment as a government is that they will comply with those arrangements. One short point to note in relation to the removals if the claim fails and chain refoulement, which my learned friend referred to. I simply invite you to read, not now, but to go back at some point on this point to paragraph 10.4, which my Lord Briggs reminded me of. The core point for present purposes is that that allows for removal, if unsuccessful through the other parts of the process, only to a country in which the individual has a right to reside. So the risk would have to eventuate by, if it's going to be chain, removal to, say, Rwanda. But if they're going to do that, they have to establish they'd have a right to reside in Rwanda. So that is an additional protection, but I say no more about that. I wanted to turn briefly then to Ilias and in-country ill treatment, in other words, my response to their appeal, and I can be very short in relation to those. So far as Ilias is concerned first, you will recall from the structure of the Divisional Court's judgment that this is where they started. The structure of their judgment was to consider what had been said and what had been considered as their first set of issues. So they deal with Ilias procedural at 46 to 61 of the Divisional Court's judgment, and they considered at the same time all the common law dress-ups of the same sort of point, so Thameside and irrationality of consideration and so on. And our submission here is that there was no error of principle by the Divisional Court. On the facts, the Divisional Court applying the thorough examination test, for good or ill, but applying the thorough examination test, and it can't get better than that from a learned friend's perspective on principle, they concluded that there had been the requisite examination of safety and so on in Rwanda, and on any view there had been reasonable inquiries. That was plainly a matter on which they were entitled to reach that conclusion. Again, there is no dispute. It goes back to whether they were applying the wrong test. I made the point when I was dealing with they didn't apply the wrong test in relation to refoulement, inter alia, because that would create an incoherence, because they plainly didn't, as everyone accepts, when they got to in-country conditions in Rwanda. The same point can be made in relation to Ilias. Here it's perfectly evident that the Divisional Court undertook its own assessment of the evidence, made its own mind up, recognising, as I think my Lord Reid reminded me, that it's not just about the executive here, it's about the courts. And so the key Ilias finding we submit is at paragraph 59 of the Divisional Court's judgment, but they dealt with what the Secretary of State knew and considered throughout this section when dealing with that matter. The Lord Chief Justice, in his judgment, agreed with the Divisional Court's conclusion, and you remember he reproached it as though he was a judge at first instance, as it were. That was a standard he was applying for himself. See paragraphs 521 to 524. The Master of the Rolls and Lord Justice Underhill found it unnecessary to decide this point. See 112 and 266. We do note at the outset it to some extent touches, although I'm not going to get into the detail of it, it to some extent touches on the point that my Lord Sales and Lord Reid were exploring yesterday about the true effect of Ilias and 134 versus 138 and all of that. But it's hard, we respectfully submit, for the reasons I think that are essentially those that were discussed yesterday and that we point out in our supplementary case at paragraph 5. It's hard to see how this as a discrete point is going to make any real practical difference in any event once you've considered the refoulement issue and the safety in Rwanda issue. But so far as the correct approach in principle is concerned, it may be thought that the analysis goes something like this. The court will either consider that there is a real risk of Syrian ill treatment, having regard to all of the material before it, including any gaps in the evidence, as part of that forensic or predictive exercise, or it won't. It is technically possible, as it were, to find a breach of the procedural obligation, but no breach of the substantive obligation, the substantive Syrian obligation. That indeed was the outcome, I think, in FG, the Swedish case, where they found that they didn't find that FG would face a real risk of Article 3 ill treatment on account of his conversion, but nevertheless made a declaration, quote, that there would be a violation of Articles 2 and or 3 if the applicant were to be returned to Iran without an ex-nunc, as they put it, assessment by the Swedish authorities of the consequences of his conversion. Maybe that gives a bit of succour to my Lord Reid's analysis of Ilias and I think it was 138. But in any event, I'm not unduly tempted to make the argument that you're allowed not to consider at all the nature of the risks when you're considering whether or not there is in fact a real risk. But in any event, the key and short point in relation to all of this is that, as I put it earlier, it can't get better for my learned friends than thorough assessment. And that, as you see from the citation that the Divisional Court took from Ilias, and indeed from their summation of what it amounted to, was precisely and in terms the test that the Divisional Court applied. But we do respectfully submit, although it doesn't matter on the facts of this case, that one might need to be a little careful about what precisely thorough brings in its wake, because there are plainly elements of judgment that a state will have to bring to bear in deciding to what extent to chase down particular lines of inquiry. And I do make that point, particularly in the light we didn't quite have it repeated in the oral submissions in this court about the Morton's fork. You're either damned because the concern is well-founded, or you're damned because you didn't investigate enough. But there is a real concern not to overreach in relation to that idea, particularly by reference to the Strasbourg case law to date. And the only cases in which there has been a problem under this examinational procedural aspect has been when the state in question really did not consider a central issue at all. So there is ultimately, probably within Strasbourg as well, despite the reference to thorough examination, as there is in our own domestic law, a bit of leeway for the state to decide what it is reasonable and appropriate to chase down. And it may well be that in future cases the Strasbourg court will need to be taxed with the distinction, if any, between reasonable inquiries and thoroughgoing assessment. Indeed, one would find lots of echoes in other case law to do with Articles 2 and 3, operational steps, only take what's reasonable and proportionate and all of that. I suspect that that is closer to the heart of this case law, but it matters not for our purpose, because our short submission is that however you crack it, there has been thorough examination, even taking that concept at its very highest. And you have, in the Divisional Court's judgment, and indeed in the evidence of Mr. Armstrong summarising what processes were gone through and all of that, you have got plenty sufficient to indicate that this was not a case in which concerns were simply overlooked. This was a case in which there was the most detailed and thorough assessment of all of these matters, both by the executive and by, see this litigation, the Court of Appeal litigation and the Divisional Court litigation, and indeed by the courts. So that takes me to Article 3, risks in Rwanda. And again, I've got almost nothing to say by way of response in relation to that. It was dealt with in the Divisional Court's judgment at paragraph 73 to 77. And we submit no error, whether of fact or law, in those paragraphs. It was dealt with by the Lord Chief, effectively relying upon and agreeing with that analysis of the Divisional Court, see paragraphs 516 to 518. We do invite you to note, in this respect, at least as a lead-in point to this, and it's perhaps more of a positive point than a responsive point, but we do invite you to note, we haven't gone to it so far in these proceedings, but one of the sets of arrangements that was set up to support the process commitments that have been given was a whole body of commitments that were given in relation to the treatment in terms of pure practicalities such as accommodation and food and access to communication and language training and all of that. There was a whole body of commitments given in relation to that as well in the reception and accommodation note verbal, which you find at page 2384 and following, and no complaint rightly is made about any of that. But it provides for, as I say, all of the things I've mentioned, and that they will benefit from all the rights set out in the Refugee Convention, including freedom of movement, employment, social security benefits, and so on. See, for example, paragraph 15. And there was also detailed evidence, principally from Mr. Williams, see paragraphs 18 to 25, in particular at page 2711, about how those arrangements were reinforced in practical terms on the ground. So there's been lots of inspections of accommodation and all of that. So the core of this case now is about dissent and taking views that with which the government of Rwanda might not agree. And our short answer to that is that the Divisional Court considered those and dealt with them properly and adequately in the paragraphs that I gave you earlier. That leaves me with one final topic, which is a topic of some, maybe thought, interest and diversion, which is the question that Lord Reid raised about the role of the appellate courts, on which we were invited to reflect, and we have done so. So if I can give you the benefit of our non-wisdom in relation to our reflections on that point. Just as a lead-in to that, we do not accept, as you know, that any of the criticisms that my learned friend Mr. Hussain made about the divisional court's approach, which he said opened the door to the Court of Appeal then doing the thing for themselves, we do not accept that any of those are well-founded. We don't accept that the Divisional Court made the error, the basic error of principle, which is the foundation, one of the key foundations for this. I'm not going to repeat those submissions. No wrong test. It's also right to note, in relation to the way in which that case was put by Mr. Hussain, that the Divisional Court did consider the UNHCR observations, and they did so in some detail. You see that in particular from a bit that you haven't really been troubled with so far because it's in the Ilias bit of the judgment, the lead-in, but they summarise them and deal with them in some considerable detail in the Divisional Court's judgment at 47 and 53 to 55. They concluded that they did not need to determine them precisely because they considered, we submit entirely correctly, that the commitments were the key. And they were correct in that, as we submit, just as the Lord Chief Justice was. They did consider the Israel-Rwanda position, and they considered in a nutshell that there was no need to chase down the detail. There was no error of law in relation to that. And in essence, the substantive consideration in relation to that was that there was no, it did not establish that there was a real risk here because of the nature of the commitments that had been given. And I developed that substantive answer very much in line with the Divisional Court's core reasoning below. He also, Mr. Hussain also said, well, the country X point wasn't considered. Well, that's something of a make-weight, if anything, but I've answered all the points in relation to country X, particularly, again, by reference to the fact that there is zero risk of that happening in our case because of the nature of the commitments that have been given. So I come then against that, as it were, a brief background in relation to the no error by the Divisional Court to the actual point of principle that Lord Reid raised, which was to give some thought to the question of the role of this court and indeed the Court of Appeal in relation to a human rights issue. And our position in relation to that is as follows. Under standard principles, even if the High Court has adopted the right test and considered all relevant matters, the appellate courts may still intervene if the appellate court concludes that the decision is wrong because, so far the case law has said, of an identifiable flaw in the judge's reasoning, such as a gap in logic, a lack of consistency, or a failure to take into account some material factor which undermines the cogency of the conclusion. And ordinarily, under that set of principles and that approach to what wrong means, it is not enough for the appellate court to conclude that it might have arrived at a different evaluation. See for that purpose the R and Greater Manchester Police case, Lord Conworth for the Supreme Court at paragraph 64, page 6191, approved, as it were, as a basic approach in the ordinary line of cases, approved by Lord Sales for the Supreme Court in Z and Hackney at paragraphs 56, 74 and 120. That's page 6435 and following. That's the first point, summarising standard principles. Secondly, it is, however, evident that this court and its members, if I can put it that way, have been giving some careful thought to the bases for that proposition in principle. That has occurred to date in the context of the appellate approach to proportionality, notably where there is an issue about the proportionality of a policy or a law as such. You understand why I put it in that way, distinguishing between that sort of issue and the case in which the issues are as to the application of a policy or law to individual facts.
Yes, I mean, you'll see in a case like Nicholson, for example, it would seem to be absurd if this court were hamstrung by the assessment that might have been made by a judge at first instance. Exactly so, and that's the point I think that my Lord revisited in some detail, distinguishing some of those other cases about individual fact application. That was the essential nature of the analysis that you and the rest of the court undertook in abortion services, as I understand it, along with reiterating that Christian Institute meant what Christian Institute meant. But the paragraphs in the analysis on this point in abortion services are paragraphs 28 to 35 in particular. And as my Lord ultimately indicated there, the task is to identify in which categories of case the appeal court should adopt a broader role for itself, including potentially deciding the very issue for itself. So it's a categorization issue that ultimately is thrown up by this analysis. And that is a question that was addressed at the level of principle in some detail by my Lord Sales in his Alba lecture, which is available on the court's website, 2020 Alba lecture, but again by reference centrally, at least, to the question as it arises in the context of proportionality. And of course it is to be recognised, perhaps this is a third point, it is to be recognised that the present issue does not concern, at least in terms or perhaps at all, it does not concern issues of proportionality. And the reason that may be of some significance because it means it doesn't have that flavour derived from, I think as my Lord put it in the abortion services case, derived from the fact that proportionality is simply the application of a well-known series of structured questions to a factual context. It doesn't arise in quite the same way, at least when that is applied to a policy or a piece of legislation and you're judging whether that is, as it were, proportionality in relation to the entire run of cases flowing through it. Our context here, of course, concerns a slightly different question, which is, with less of that flavour of principle potentially, which is whether or not there are substantial grounds for believing, etc. In other words, it's the Suring real risk test. However, and it is important that we recognise this, however, we do recognise that there are, as a matter of general principle, powerful factors in favour of a broader role for the appellate court, including in particular this court, in some human rights circumstances. And the reason that we recognise that are essentially those, without cribbing unduly, that were identified by Lord Sales in his lecture, and some of which were referred to by my Lord Reid in your judgment in abortion services. Rule of law, consistency, utilising the wisdom and experience of superior and senior judges, the approach which would be adopted if the case were heard in Strasbourg and the extent to which they would accord margin, all of those features favour, as a matter of general principle, a somewhat broader role for appellate courts in some circumstances. And we do accept also a point that I think was drawn out in Lord Sales's lecture, that there is at least an analogical force with some comparison between the way in which as it were, the doctrine of margin or respect works within our constitutional arrangements and the sort of factors that would influence how broad that respect or margin is to be. There is some analogical force in the comparison between that and the position, on the other hand, of an appellate court versus a first instance court. So you're doing the comparison, as it were, within the constitutional arrangements to see whether those, but not to put too fine a point on it, to see whether those things that have led to the respect of the first instance judgment in previous cases are actually applicable in the context that you're considering. Ultimately, it may be thought that the governing principle is no more and no less complicated than that the role of the appellate court and the way in which it approaches an issue will depend upon the context. And the various factors that have been identified in abortion services and indeed in Lord Sales's lecture may pull in different directions and may thus have to be weighed
in the particular context before the court. And there is likely ultimately to be a spectrum of cases. The example I think was given in abortion services of cases where you're dealing on the one hand with, at the far end, left-hand end of the spectrum, with simply the application to the circumstances of an individual case, and on the other hand where you're dealing with a pure challenge to a policy as such, or a pure challenge to a piece of legislation. I suppose the final point of principle to make in relation to this matter is that even in a case in which this court considers that the factors do point towards a more interventionist role for an appellate court on appeal, it is almost inevitable that the court will pay particular and careful attention to the facts found below and to the relative advantage or disadvantage or none of the lower court in relation to that. And the courts have frequently, readily, and we submit properly, recognised the force of the point that the first instance court is very often well placed, even when there are no live witnesses, and perhaps best placed to make the judgments about the facts. And that may well be for purely practical considerations, because they have, as the divisional court had here, 8 days, if that's the privilege, to determine issues as opposed to 2 or 3 because of the ravages of time. But the point remains that even if you assume a broader role, that doesn't exclude your according that degree of respect in appropriate cases. We can, to bring it closer to the present case, readily understand and accept that the present case does involve an issue of general principle, the answer to which will affect many persons not before the court, and on which the likelihood is, if the case is allowed to go this far, that we will go to the European Court of Human Rights in Strasbourg, and so all those considerations about margin are in play in a case such as this. That is particularly so, perhaps, because, as I noted in opening, we do submit that the Lord Chief was right to identify the true nature of the issue in this case. That's why I described it as a preemptive challenge. It is a challenge that says it's almost the obverse of a proportionality challenge to legislation saying all cases flowing through it will be proportionate as long as you apply the rules. It's almost the obverse of that. So here we've got a case where the other side are making the opposite contention. No one, not a single individual, can be removed is a submission that is made at this stage because the nature of the risk is such. So ultimately, if it isn't too fluffy a conclusion in relation to all of this, it will be for this court to consider whether those factors, that set of factors which we do submit, can properly move into this context, as it were, whether those factors will have a role to play in a case such as this. It may, of course, be very difficult to transpose directly the abortion services reasoning, because that was about proportionality, not real risk. But the underlying level of principle, all the factors that you consider there that Lord Sales considered in his lecture, can legitimately, as a matter of principle, play in a variety of different ways in a case like this, in this context. I say in a variety of ways because it could be, as it were, an all conclusion. It's for you just simply to say this is the sort of case that falls within that category, and therefore we're going to do it ourselves. We're going to strike the balance. We're going to make our own judgment up about, our own minds up about whether there was a real risk. Or potentially it could play, and again, we can't see any objection to this in principle, it could play in relation to the approach that you take, and I think it's a question my Lord Sales asked my learned friend Mr. Hussain. It could play into the question of how you approach the concept of wrong at the appellate level, and how much leeway one gives, how interventionist a role this court chooses to take.
But my understanding is you're not positively submitting that this is a sort of case where an appellate court should substitute its own opinion as if starting de novo.
My Lord, you will have seen from our case, if I'm allowed to plead our own inadequacy of consideration in prey, but we in our case have taken the position that the position is wrong is the flavour, wrong is the test, and the divisional court were not wrong, so the Court of Appeal had no business interfering. But we were invited to reconsider the issue in the light of the case law which no party had considered, and we have done so. And so I hope it's fair, at least for me, to set out, having reflected on it, where we've ended up. I'm not sure I go as far as to say...
Encapsulate where you had ended up.
Yes,
it seemed to me that you were positively submitting, even after reflection, that this is a case where this court, whatever the shade of meaning of wrong, is properly positioned to start afresh and just make up its own mind regardless.
I don't make that positive submission. No. I do say, however, that it is open to this court to take into account those factors and to apply, as it were, a rather more interventionist approach than you would otherwise do to your assessment, if you consider that that's the appropriate thing to do. And that's why we've paid particular attention to the nature of the factors as a matter of principle that underpin the proportionality analysis in abortion services. Yeah. So that's why I said I hope I'll be forgiven if it's a bit of a fluffy conclusion to it, but that's where we've ended up.
That's very helpful, thank you. I think I raised the point because at the stage in your submissions that we were at, it had struck me that it would be unfortunate if the fate of an important government policy turned on our construction of some words used by the divisional court.
Yes, well, my lord.
Members of the Court of Appeal had construed in different ways.
My lord, I respectfully agree with that, and I respectfully agree with that, particularly if the case ever were to go to Strasbourg. That would be a thoroughly unfortunate place to end up. I mean, theoretically possible, one would say, well, they didn't go wrong, but ho-hum, who knows who was right when they got to the facts. That would be a very undesirable place to end up, I respectfully submit. Yes. So that's why we've reflected. And as I say, my submission ultimately is not to positively invite you, but likewise not perhaps to stick too rigidly to the line taken in our case pre-reflection, and to acknowledge that the door of principle is open to you to take a more interventionist approach if that's what you choose to do.
Yes, thank you very much.
Also, I'm sorry, I've gone a little bit over time, but my friends, I hope, will forgive me, and it allows them to, my learned friend Mr. Hussein's short response.
Half an hour yesterday.
Yeah. Yes. Unless I can assist.
No, thank you very much, Sir James.
Do you want this?
Mr. Hussain.
My lords, thank you. I'm going to be very short. One point of correction, if I may. I did not accept in my oral submission that ex facie the assurance cover the problems, and we see that, and our case indeed makes the positive case they don't. If you look at paragraph 60 of our case, page 349, that's all I want to say about that, if I may. Then in my reply, I'm going to restrict my reply to Ilias, ground 4, and if I may please make short points, 3 of principle, 3 of application. The first point of principle, Sir James seems to suggest that assurances may be an answer based upon paragraphs 158 and 161 of the judgment. It's enough, he seems to suggest, to the duty that you get assurances. That's obviously wrong with respect, if you look at one of the key paragraphs, 141, page 1817, and the focus there on practicalities, no surprises, practicalities. Second point, thoroughness. What does that mean? We say there is a qualitative element there as well. One has to bring some critical faculty to the material, and we see that from the focus on the sufficiency or otherwise of examination in 2 paragraphs in the court's judgment, 158, page 7820, and paragraph 160 at the top of 7821. The complaint wasn't that the courts hadn't looked at the material at all, they hadn't looked at it sufficiently. And that's obviously the threshold question, what is thorough, what isn't. It's obviously going to be context-specific. The context here is system-wide change of a system that is profoundly deficient in our respectful submission. a deficiency accepted by the dissentient as well as the majority below of the Court of Appeal. Third point of principle, the Divisional Court thought that mere consideration of the material sufficed to discharge that duty. We say not so. Ilias sets a standard, a legal standard of thorough examination, compliance with which it is for the court to adjudicate upon, and the Lord Chief Justice at 489 also accepted in terms that the test had an objective element. The breach of the duty here, the application, High Court appeal, my Lord Briggs, Sir James says no evidence. Well, quite. Needed to be examined. Why not? Why has there been no appeal for 5 years? It suits Sir James to focus upon April onwards. What about the earlier period? Second point, High Court independence. It is not the case, contrary to Sir James's submission, that the issue only arose in the litigation. In the run-up to the assurances being negotiated, His Majesty's government itself made the point, the FCDO put the Secretary of State on notice that this was the problem. I gave you references yesterday. It's the FCDO reviewer at page 3101. It's the passage cited by Lord Justice Underhill. The first part of the passage refers to lawyers. The second part of the bubble, page 3101, refers to the independence of the judiciary. Government themselves making the point about the problem of High Court independence. The third point I wanted to make, my final point, concerns Israel-Rwanda. The key to the relevance of Israel-Rwanda, as a matter of principle, obviously it is relevant. See Zabaletny, my Lord Lloyd Jones. But here, the reason it is so relevant was that that arrangement was also designed with the very purpose of Rwanda processing asylum claims. And if that was an answer, that's an answer here, one would have thought it might be an answer there. Yet, the DGIE didn't stop behaving as it did by reason of that objective, and you heard submissions yesterday on that. Those are my submissions, my Lords.
Thank you very much, Mr. Hussain. Yes, Mr. Drabble.
Well, as your Lordships know, my task is to address the issue of whether it's actually Article 27 of the Procedures Directive survives as retained law. If it does, and we say it does, then it's common ground that individuals cannot be sent to Rwanda unless they have a connection with Rwanda, and there is no suggestion in any case that they do. So it's a fairly basic issue. Now, I propose to, just so the Court knows where I've got to in the course of the submissions, to address the Court under the following headings, content of which, some of which is short. First of all, to set out our basic proposition. Secondly, to take the Court in some detail through the provisions of the relevant Act, ICSA. Thirdly, to take the Court to the material that shows the existence of a potential difference between legislative references to immigration and legislative references to asylum. Next, to take the Court to material showing that the Act with which we are concerned is limited to immigration in the narrow sense in which Lord Justice Underhill described. In other words, that the legislative references in this Act are to immigration and not to asylum. Fifthly, to take the court shortly to the cases on statutory interpretation that we have set out in the case, with the object of showing that our basic proposition is formulated in a conceptually correct way, and at the end of the day receives the answer that we wish to give to it. Next.
It's perhaps just remarking for the benefit of those who are trying to follow this hearing that if you're right about this, this is a complete knockout blow.
Yes, it's a knockout blow at the moment, and the moment includes all cases in which a notice of intention has already been served, and any arrivals in the UK until the end of this calendar year. Yeah. So we are dealing on the law as it presently stands in some tens of thousands of cases are directly affected by the issue of construction that we raise. Yeah.
And in a nutshell, the issue is that EU law bans the removal of asylum seekers to countries in which they have no previous connection.
Yes.
And your contention is that that part of EU law has been retained in force in the UK since our withdrawal from the EU.
Indeed. Yeah. And the relevant part of the EU law is contained, as the court and those watching will see in due course, in Article 27 of the Procedures Directive. Yeah. The critical issue is whether the Procedures Directive remains retained EU law. If it does, then the consequence which your Lordship has just spelt out follows. And so I was going to, as I said, I think I've got in my list of taking your Lordships to cases on statutory interpretation. The references are short, but it is our case that Lord Justice Underhill's final conclusion is not compatible, at the end of the day, the reasoning which leads up to it is not compatible to the task that he should have been carrying out when applying that case law on statutory interpretation. Next, summary of the factors that should lead the court to the conclusion that the objective construction of the statute is as we say it is. Most of those will have already been covered, but they include at least some reference to the nature of the right that on the government's case is being removed, namely the right to apply for asylum in the United Kingdom and to have that claim assessed in the United Kingdom rather than to be removed to Rwanda without any assessment of the merits of the case. And then finally, a return to the central reasoning of Lord Justice Underhill and the submission which I've already foreshadowed as to why that cannot stand. Now, the basic proposition, first task, we say is as follows. The basic proposition is that the objective meaning to be ascribed to Section 1 and read together with paragraph 6 of Schedule 1 of ICSA, if I continue to use that shorthand, is that they are concerned with the repeal of provisions relating to free movement and immigration in the narrow sense, and not with the repeal of provisions relating to asylum. That formulation is designed to set out the result of the approach to the issues of statutory construction, which I've already promised to take your Lordships to. The objective meaning is what we're looking for, can and should be ascertained by examining the text, obviously, of the statutory provisions, that's Section 1, and the whole of Schedule 1 paragraph, the whole of Schedule 1, in particular paragraph 6. The objective meaning, therefore, of the text, the indications as to their likely content to be given by the short title the preamble, the headings to the various provisions, and, importantly, the explanatory notes that accompanied the bill when it was deposited, and indeed were substantially repeated at the time of the Act. Your Lordships have both the explanatory notes at the time of the bill and those at the time of the passage of the Act in the bundles. The first task is to go to the Act. I hope your Lordships have picked up that the electronic bundle containing the complete text of the Act was submitted by the parties towards the end of last week. The bundle in the copy of the Act in the bundle does not contain all the provisions. So you can make the main arguments from it, but there should be an electronic bundle containing the provisions of the Act itself, and I hope it's found its way to your Lordships.
Yeah, I'm sure it has. Is this
I think it's an ASM additional bundle.
Yes.
Yep, got that.
Could you help me on that, please?
It does have the effect, for the purpose of these submissions, that the page references don't work. It's an internal, it's a self-contained bundle.
So we have to look at that, and there's an 18-page bundle there.
Yes.
Yeah.
Well, it's just checking that that is right. Yes, it's an 18-page bundle.
Yes, thank you.
Which includes pages 1 and 2 are actually the frontispiece.
Yes.
So it's 3 to 18 is the Act.
Thank you.
No, you said you'd bring copies of the Act. I said we'd bring copies of the bill, but we haven't. There's an exchange about who agreed to bring hard copies, but in the event, if your Lordships all have it, we can act entirely off the electronic copy. And as I've said already, a copy of the bill, if your Lordships were at any stage to be interested in what it looked like when deposited, is in the bundle at the correct page numbers referred to in the index. It's helpful to have it, not least because the explanatory notes that relate to the bill obviously refer to the bill and not to the Act.
Yes. Are you able to give us a page of reference for the bill?
The bill sorry. So yes, there's a note on the very front page of this bundle.
Page 2.
Page 2. Sorry.
Of the additional bundle.
Of the additional bundle, says the bill as originally introduced appears at Appendix 27. Oh. It's page 8028 is what your Lordships need.
Thank you very much.
So going to the Act and just simply working through it, the following features are important. First of all, the short title is set out on page 3 of the bundle and is simply the Immigration and Social Security Coordination brackets EU Withdrawal close brackets Act 2020. Your Lordships may or may not have picked up that we put in front of the Court of Appeal, and I think the Divisional Court as well, a schedule of short and long titles of various statutes, I'll take your Lordships to it, which contain a discrete reference to both immigration and asylum. In other words, where on the face of short titles and long titles and the preamble, the distinction appears in the way which we say is commonplace in these legislative schemes, but not present in the present statute. So, short title, reference solely to immigration. Then working our way through the headings, your Lordship looks at...
Just on that,
I mean, the Immigration Act 1971 would cover asylum as well, wouldn't it? Parts of it.
Yes. It's not our case. It's not a necessary part of our case that you have to find within the short title a reference to asylum. Come back to my basic proposition. What is the objective meaning to be given to section 1, which we're going to come to very shortly indeed, read together with paragraph 6 of Schedule 1? What is the objective meaning? Does that include a reference to asylum?
Sure, but I thought you seemed to be making a point that there is, I don't know, an established convention in terms of the titles of acts.
No, I don't need to say, and I don't say any more than it is commonplace for the distinction to appear on the face of the statute. Yeah. On the face of the title. Because, I mean, at the end of the day, the court in this exercise has to decide whether it is significant that there are references to immigration or asylum.
Oh, certainly, yeah.
It has to establish what the objective meaning to the reader is. And we say that when all the material is considered, it doesn't include asylum and does include immigration in its narrow sense. That's the heart of the case. So, short title, page 5. Long title, or preamble, is an act to make provision to end rights to free movement of persons under retained EU law and to repeal other retained EU law relating to immigration, to confer power to modify retained direct EU legislation relating to social security coordination, and for connected purposes. Now, pausing there, plainly an act making provision for the repeal of asylum would not be making provision to end rights to free movement of persons. So we're not in that part of the long title. A live question on the preamble or the long title is what is meant by other retained EU law relating to immigration. We say, when you consider all the material, it is actually crystal clear that the reference to other retained EU law relating to immigration means immigration in the narrow sense and not asylum. And then there's a reference to social security coordination and a reference to connected purposes. So far so good. We then go into part 1. The relevant provision on which the Secretary of State depends and which Lord Justice Underhill construed is paragraph 6 of Schedule 1 to the Act, that is in part 1. So we are dealing with a statute, we are dealing with a provision in part 1. The description of part 1 under the heading is measures relating to ending free movement. No reference to asylum. On the face of it, according to the title, the whole of part 1 relates to measures relating to the ending of free movement. Then we come to section 1, which introduces, as your lordships will see, schedule 1. So the heading to section 1 is repeal of the main retained EU law relating to free movement, etc. Now, when we look at the detail of the argument, on the Secretary of State's case, the word etc. is having to do a huge amount of heavy lifting. It's the word etc. is the only way in terms of these headings, to a description of the provisions that we're looking at as covering asylum. And at the end of the day, it's going to be, to my submission, is that the objective meaning of the statute would not give the weight to the word etc. the meaning which it's crucial for the Secretary of State to give it. And when we look at the explanatory notes, there's a perfectly straightforward explanation of why there's an etc. governing free movement. It's to deal with other retained rights, such as Chen and Zambrano, and rights of residence that are do not stem from the Free Movement Directive. And then the provision, then Section 1 states, Schedule 1 makes provision to A, end rights of free movement of persons under retained EU law, including by repealing the main provisions of retained EU law relating to free movement. So pausing there, nothing in little a that brings in asylum. And then B, end other EU-derived rights, repeal other retained EU law relating to immigration. So, given that I can establish and do establish that there is a distinction between immigration and asylum seen on the face of many legislative schemes, I think is probably as far as I need to go, the question arises, if you stop at 1B, what is the natural meaning, or what is the objective meaning to be given to the reference to immigration? And we say, considering the totality of the material which this court has to consider, immigration there means simply the narrow meaning of immigration described by Lord Justice Underhill. So stop there, and we have got nothing on the face of it to indicate an objective meaning that extends to repealing the provisions relating to asylum. We go into Schedule 1. Your Lordships will find that at page 12 of this bundle. Schedule 1 repeats, Schedule 1, the heading to Schedule 1 repeats the formulation that we have just seen over Section 1, unsurprisingly, as Section 1 introduces Schedule 1. And I repeat the comment about etc. On the face of it, we're dealing with a schedule which, according to its title, is repealing maintained EU law relating to free movement, and then there is the reference to etc. I'll see what the explanation for that is in due course. Then if you look at the substantive provisions of Schedule 1, all of them, but for the words which this court has to construe, unambiguously relate to free movement. So that Part 1 is, of the schedule is dealing with EU-derived domestic legislation. And your Lordships can see without me reading what paragraph 1 says. And there are various other provisions which are designed to end the existence of free movement rights. Part 2 is retained EU legislation. It omits Article 1 of the Workers' Regulation. That's a pure free movement provision. and Articles 2 to 10 are modified, but again are dealing with free movement. And then paragraph 5, you get the favour of paragraph 5 from 5.1b, Annex 1 of the Swiss Free Movement Agreement. Ceases to be available, recognised and available in domestic law, and the Swiss Free Movement Agreement is defined in paragraph 5.2. And then we go into the provision which we actually need to construe. I'll just read the whole of it. Any other EU-derived rights, powers, liabilities, obligations, restrictions, remedies and procedures cease to be recognised and available in domestic law so far as A, they are inconsistent with or otherwise capable of affecting the interpretation, application or operation of any provision made by or under the Immigration Acts included as amended by this Act. And there's a definition of what are the Immigration Acts elsewhere in the statute. And then I don't think I need read to...
So can I just ask, is there a definition of the Immigration Acts in the Act?
So, yes, if your Lordships go back into the... It's section 4 of the Act.
Which page is that?
So page 7 of the bundle.
Yes, thank you.
Secretary of State's case, ultimately accepted by Lord Justice Underhill, was that because asylum, the grant or refusal of asylum affects leave to enter, then an immigration rule dealing with leave to enter in an asylum context might be inconsistent with or capable of affecting the interpretation of the Immigration Acts as defined in the provisions referred to in Section 4 and Section 4 itself of this Act. Our substantive case on paragraph 6 is that the reference to immigration in 6.1b is in context when one is searching for the objective meaning to be ascribed to the statute, a reference to immigration in the narrow sense envisaged by Lord Justice Underhill. It's a reference back to section 1b, at page 5 of the bundle, under the heading Measures Relating to Ending Free Movement, and in context plainly relates to either free movement itself or something closely connected with free movement, and we'll see what the explanatory notes say about it in a moment. So if I'm right so far, then the position is that the whole of Part 1 of the schedule relates to free movement. The whole of Part 2 of the schedule relates to free movement. The fallout words of 6.1b relate to immigration in the narrow sense, stroke free movement. And the one exception are the very wide words on the face of it, the literal meaning of the words, I'll come back to that, in 6.1a. No other indication at all of an intention to repeal a whole corpus of asylum rights, the content of which I'll come to in a moment. So the question is, what approach does the court take to arriving at the objective meaning of the reference in 6.1a to something being inconsistent with any provision of the Immigration Acts? The short answer, we say, is that you read 6.1a in the light of the provision introducing it, namely Section 1. You ask yourself, does 6.1a on the Secretary of State's construction relate to ending of free movement? Answer, no, on the Secretary of State's construction, or at least it isn't limited to that. Is it consistent with Section 1b, ending other EU-derived rights relating to immigration, when that reference to something relating to immigration is read in context? At the moment, I've just been looking at the headings to the statute, various provisions of the statute. And the answer we submit is no. Objectively, this whole set of provisions is designed to end free movement rights. And so 6.1 is subject to a limitation that the rights in question relate to immigration. Could be drafted any other EU-derived rights, etc., relating to immigration cease to be recognised and available in domestic law insofar as A or B. If that is not correct, then the result is, on Lord Justice Underhill's own approach, the accidental removement of a corpus of asylum law without anyone having thought about it at all. That, I think, is the case I have to meet. So that's my I think probably second heading on the list, the run through of the main provisions of the Act. The next question, or the next heading on my list, is there a potential difference in various legislative schemes between concepts of immigration and asylum, which should be taken into account when considering the drafting of the Act? If your Lordships have Mr. Lord Justice Underhill's judgment at 352,
Sorry, bear with me one moment, if you would.
352 is page 314 of the bundle, Reference.
314.
Yep.
314 in the key documents, not the...
Mr. Appel, do you have the page number in the main hearing bundle?
I think it's 314.
No, it's 575.
Oh, sorry. Then I'm going to make that mistake again because I've removed it for my own purposes. I thought I got it out of the main bundle, but I obviously haven't. Someone can shout when we come to the judgment provisions. I think it's only the judgment. would think it's only the judgment.
352. 352 on the hard copy.
Paragraph 352.
Paragraph 352. Thank you. Sorry to hold you up.
Sorry about that.
That's my fault.
I hope we're now at 352 anyway. And if I can just invite your lordship to read 352, but essentially it is setting out the case which I repeat today. And while we have the judgment, a place to find the long list of the Immigration Acts is paragraph 349 of Lord Justice Underhill's judgment.
And you don't challenge the accuracy of that list?
No, not at all. No,
we don't have to trawl our way back.
No, no, you don't.
Rather oblique definition to which you referred us a minute ago of Immigration Acts.
No, I mean, the only relevance of Section 4 is that it's putting into the list this statute. I mean, your lordship will have gathered there's no dispute on our side that say the provisions of the Immigration Act relating to leave to enter are a provision in the list of Immigration Acts that are set out in Lord Justice Underhill's judgment and are brought into the statute. The question is, how do you treat the relationship between the two limbs of paragraph 6 and section 1, given the fact that section 1, on its face, the face of the title, is relating simply to free movement, and there is a perfectly straightforward and, in our submission, correct construction of section 1, which is limited to free movement of immigration in the narrow sense. What do you then do when you come to the schedule, almost all of which is unambiguously concerned with free movement, apart from the opening words of 6A? Now, our case, which I think, I hope, if I can then take your lordships to paragraphs 5 and 6 of our case, which I hope is at page 382. And 383. And your lordship will see we say in paragraph 5, towards the foot of 382, immigration and asylum are distinct concepts in EU law which are subject to separate legal frameworks. EU immigration law is concerned only with free movement of rights of EU nationals and their family members as set out in the Citizens Directive. EU immigration law is not concerned with the rights of third country nationals, save insofar as they have derived rights of free movement of residents due to their relationship with an EU member state. Entry of residents of third country nationals who are not refugees and who do not have rights derived from free movement of EU law, a matter for individual member states. And then by contrast, EU asylum law is a separate and self-contained body of law, the EU Common Asylum System, CES. The purpose of a common asylum policy, of a common EU policy on asylum, reflected in the recitals to the main asylum directives, is to establish an area of freedom, justice and security and justice open to those who, by forced by circumstances, legitimately seek protection in the community. And then there's a reference to the first phase of CEAS set out in the recitals to the Procedure Directive. So can we then go to the Procedures Directive, which is the piece of EU law which contains the requirement for connection with a safe third country before you can be removed to that safe third country, which is at the heart of our case. But on the way, we pick up the recitals. So if your lordships will look at page 4109 of the bundle. We should be in Directive 2005/85/EC, otherwise known as the Procedures Directive. And recitals 1, 2, 3, 4, and 5 set out the EU legal framework within which the Procedures Directive is made. Read it all, but for example, recital 1 states whereas 1, a common policy on asylum, including a common European asylum system, is a constituent part of the European Union's objective of establishing progressively an area of freedom, security and justice open to those who, forced by circumstances, legitimately seek protection in the community. And then that is amplified in 3, 4 and 5. So you have a body of law described in these recitals which relates to asylum and is clearly distinct from the Free Movement Directive, the Citizens Directive, with which we say this statute is certainly primarily, and we say almost exclusively, concerned. And so to repeat, Secretary of State's case is that this whole corpus of law described in the policies set out in the recitals has been repealed without anyone lending their mind to it. See the conclusions on that issue of Lord Justice Underhill, to which I'll come back. Then we have at page 4112 a series of general provisions. Article 1 describes the purpose of the directive. Article 2b is important because of a case called GVG, a Supreme Court case which proceeded on the basis that the Procedures Directive was part of retained law even after the enactment of the statute with which we are concerned, and I'll come to that in a moment. There's something of an issue below about whether or not the comments of Lord Stevens, who gave the judgment in GVG, observing, recording the Secretary of State's acceptance that the Procedures Directive was retained EU law, was part of the ratio, plainly was part of the ratio, because when we come to it, do as shortly as I can, but the phrase that was key in GVG is in the definition of an application for asylum, which, as your lordships will see, means an application made by a third country national or stateless person which can be understood as a request for international protection. And the words "can be understood" were relied on by Lord Stevens after the commencement of this statute to say that the reasoning of the Court of Appeal in GVG could not stand. So it's part of the ratio, but it's unargued, and I can't say there's any binding judgment because of the complete lack of argument on the issue. But
the point about the continuity, the point about retained EU law wasn't taken.
The Secretary of State, it wasn't argued. The Secretary of State was asked, do you accept that the Procedures Directive is retained EU law? The answer is yes, he does accept it. But it's not argued. I mean, no one was contending that it wasn't retained EU law. And your Lordship may or may not have picked up, and certainly can pick up at your leisure, if I can put it like that, that in an earlier case of Robinson, before the commencement of our statute, the Secretary of State submitted that the position in relation to the Procedure Directive would not change on the commencement of ICSA. So there's to Lord Stevens. So Lord Stevens knew about ICSA, thought that it didn't mean that they ceased to be retained EU law, but there was no argument. Now, and then if we go on Article 7, page 4114, provides a right to remain in the member state pending the examination of the application. So that's a substantive right that's in play in GVG, is also relevant here, because you cannot disapply that right to remain in the member state pending the application or pending the examination of the application, except in accordance with the provisions made in Articles 23 onwards. We'll just go to page 4120. Procedures at first instance, and then Article 23 describes the examination procedure. Article 25 describes inadmissible applications. And 25(2) provides that member states may consider an application for asylum as inadmissible pursuant to this article if, and then the various factors set out, but they include concept of the safe third country, which is further described in Article 27. And that's the heart, that's 27(2)(a), which is the provision which we say renders the scheme for removal to Rwanda unlawful if the Procedures Directive is part of retained EU law. So 27(2) states the application of the safe third country concept shall be subject to rules laid down in national legislation, including A, rules requiring a connection between the person seeking asylum and the third country concerned, on the basis of which it would be reasonable for that person to go to that country. And the Secretary of State accepts that if that is still part of domestic law, the scheme, the Rwandan scheme, falls, because it doesn't require a connection. In fact, there will almost never be a connection. Now, as I say, the Secretary of State's case is that the whole of that corpus of law, the qualifications, including the Qualifications Directive, are simply swept aside by virtue of the opening words of paragraph 6, Schedule 1. Nowhere else in the ICSA statute is there any reference to asylum. So that's the construction issue which the court has to determine. Now, if we then go on to other material that demonstrates the existence in various legislative schemes of separate concepts of immigration and asylum, I invite your lordships to look, first of all, at paragraph 11 of our printed case.
Sorry, paragraph 11.
Paragraph 11. It's a page of our case, ASM case, page 384 of the bundle. And this is in a piece of Brexit-related legislation, namely the Immigration, Nationality and Asylum (EU) exit close brackets regulations 2019, and the structure of the regulations we state in the case dealt with revocations related to immigration and nationality and revocations related to asylum in two separate parts. And we say that reflects the distinction that we are after. And if the court will look at page 3887 of the bundle, we have the two schedules that we've referred to in our case. Part 1 is indeed headed Revocations Related to Immigration and Nationality. And then your Lordship can run an eye down the provisions which are brought into play. And then
it could be said that that reflects a particular context of EU law where asylum belongs to the common framework on justice and free movement belongs to the single market.
Yes, well, I'm totally willing to accept that. I mean, that just brings you back to the question of construction of paragraph 6 of Schedule 1, read in the context of the introductory remarks I've made about the preamble, the headings, and section 1.
Yes, so your argument isn't that there's a general convention in statutory drafting in the UK that immigration and asylum are distinct topics.
Yeah, that's not necessary.
In the context of EU law, there's a clear distinction drawn.
Yes. We're left. Yeah, I accept that.
Yeah.
I mean,
you say the subject matter of ICSA is.
The subject matter of ICSA is pretty well exactly the same as the subject matter of the 2019 regulations. And can I just take the point just one stage further? If your Lordships go back to 3887.
Sorry, page?
3887. We're back into Schedule.
Yes.
Part 1, sorry. Revocation of retained EU legislation, Part 1, revocations related to immigration and nationality. Your Lordship will see in small typeface that the same line as Schedule 1, reference to regulations 47 and 54. Which are, unsurprisingly, the regulations that introduce, in the case of Regulation 47...
So sorry, which page are you on?
3887.
Sorry, thank you.
What has found its way into the bundle is the full text of Part 1 and Part 2 of the schedule. They are introduced in very short terms by the two provisions referred to at the top of 3887 on the right-hand side of the page, regulations 47 and 54.
I'm sorry, I didn't see it.
Print, yeah.
Robert?
Yep.
Sorry, I couldn't work it off.
Right.
It's in very tiny print.
Yes, right at the top of the page.
It's in very tiny print, right at the top of the page.
Yes, the top right-hand corner of
But there is a sharp and quite important point, actually.
Yes.
Sorry, just as I understand, is that indicating the regulations which give effect to the schedule?
Yes.
Yeah.
Right.
Yeah.
Yeah, there's the regulations which give effect to the schedule. And if I can just... Your Lordships can no doubt go at your leisure, or we can supply hard copies if your Lordships want us to. But Regulation 47 is actually quite instructive to this construction exercise. And if I can just read it.
Sorry, it's not in the bundle.
It's not in the bundle, and as I say, we can supply it. But it's not of such length that your lordship will be troubled by it. Can I just read it? 47, revocation of retained direct EU legislation relating to immigration and nationality. So the phrase in the heading in Regulation 47 is EU legislation relating to immigration, which is exactly the phrase that falls to be construed in Section 1 and paragraph 6b, and the query what you do about 6a in that context. And the regulation itself just says Part 1 of Schedule 1 has effect. Now, as I say, we can provide hard copies of that single liner if it's helpful, but so it's not just, to go back to Lord Reed's question, it's not just that in EU law there is a well-trodden distinction between provisions relating to free movement and provisions relating to asylum, as explained in the recitals to the procedures directive that we've seen. There is also, in Brexit-related legislation, admittedly subordinate legislation, a reference to the concept of retained EU direct legislation relating to immigration.
Yes. So you say when legislation is concerned with retained EU law, it draws a distinction between retained EU law relating to immigration on the one hand and relating to asylum on the other hand.
Well, certainly in this example, it does. The question is viewed objectively. What is the meaning to be ascribed to the concept of relating to immigration in Section 1? And we say it's the narrow concept. Because, of course, Reg 47 sits alongside Reg 54, which introduces the provisions relating to asylum, as your lordships can see from Part 2 of the regulations, at 3889. Headed, revocations relating to asylum. Now, going on through the material, with an eye on the time, that we introduced in the Court of Appeal, and I think the Divisional Court, the table of long titles that we've already seen Lord Justice Underhill referring to. And it's at page 2356 of the bundle. And your lordships can see them. It's already been pointed out that the Immigration Act 1971, the short title, refers similarly to the Immigration Act 71. But lordships will see that there are many of the short titles that refer to Asylum and Immigration Acts. And a lot of the long titles. For example, the 1999 Act, an Act to make provision about immigration and asylum. The 2002 Act, an Act to make provision about nationality, immigration and asylum. 2006 Act, your lordships have the point. Now, the lordships Underhill points out it's not universal.
What is the point that you extract from the table?
The point is that this, when you are looking at our statute, you are looking for an indication of what the subject matter of Section 1 and Paragraph 6 is. You start with the short title, which doesn't refer to asylum. You go next to the long title, which doesn't refer to asylum, despite the fact it frequently does. You then go on, as I've already said, to the headings, to the individual provisions. And your Lordship has seen the heading to Part 1, which is simply a provision relating to free movement, I think.
What propositions do you draw from the table?
I draw a proposition from the table that it is possible to draw a distinction between references to asylum and references to immigration, which are at least an indication of the objective meaning to be assigned to the provisions that fall to be construed.
Thank you.
Now, is that a convenient
That will have to be, I think.
Yes. Well, thank you, Mr. Drabble. We'll resume at 2 o'clock.
Indeed.